Attorney Brian Parker here, giving out the good stuff. Today we have the other side. The last video was how to answer in detail a creditor lawsuit. Now we're going to look at a debt buyer lawsuit. These are my favorite. With debt buyer lawsuits, I just know I'm going to win them. With creditor lawsuits, you've got to find as many things as you can to get yourself in a settling position. And you're going to allege things you're not sure of right away. As I just did the, let's put that up, the Cap 1, how to do a creditor lawsuit, Cap 1. That is a typical creditor lawsuit. Today is going to be a typical debt buyer lawsuit. And we're going to use Midland Credit Management because they're just typically fun and bad and good for you. So the 4 things we want to look at, first of all, let's put up a very good series for you, the analysis, the 5-part series, just 8 minutes each of how to analyze a complaint and break it down. There we go, all 5 parts. There it is, check those out, okay, there you go. So let's put up what we want to look at today. So Shazam, we want to tear apart the pleadings. We want to do the document, show every assignee and assigner proof of the assignee. Does the loan agreement help you? Governing law, anybody? Very popular video, in spite of the fact as I was doing it. Let's put the governing law video up there. People just like, I don't understand what you're saying, yet everybody loved it. So, does any bill of sale or transfer document have a forward flow agreement or false statements? Put up the governing law video and the affidavit video and the assignments video. There's all 3-part, all 3 in a week. And do the pleadings make any sense? So that's your analysis when you're doing a debt buyer lawsuit. Midland Credit, UHG, PRA, Crown Asset, they're all the same. Even student loan, private debt, they're all the same. They come from the same model, and they just pump these out by the thousands with no care. But you're being sued, so that's why you put in the care and make yourself look like an educated consumer and their worst nightmare. So here is a typical, in fact, in that vein, here's some videos I've done on Midland Credit, UHG, PRA, Crown Asset, all the assignment and governing law videos, everything in student loan videos, SLM, all those videos are there for you to plunk into whatever case you have. When it's a debt buyer case. It's all based on assignments and bad bill of sales. Now let's put up the Midland Credit typical first page of the lawsuit, Shazam. And that is your typical, you're going to see there's a caption. And I point that out because your caption on your answer has to show a mirror effect. You're the defendant, you're going to break it down, you're going to put the case number, and you're going to identify, when you do that analysis with those videos of your case, what is the linchpin of the whole thing. Put up my 2 videos. There's at least 2. There may be even a 3rd with Midland Credit linchpin videos. You're identifying that if you took that piece of the house of cards away, the whole thing would come down. So here we can see, I can tell you the linchpin is they are saying MPLI Capital Holdings the 4th has passed the debt on. That's a hint and a half. When a debt buyer places trust information into the lawsuit, and what they're doing, they're just figuring out guys like me and you are going to come along and go after the trust. They're trying to get ahead of you, but it just makes it worse. Whenever they try to make it better, it just makes it better for us and worse for them. And here's the 2nd page of the lawsuit, Shazamski, and that is just more nonsense. If you look at 7, they're saying, we've acquired all the title, rights, interest to defendant's account, and we've attempted to contact defendant through several means in an offer to resolve the account. What those 2 things in the same sentence have to do with each other, I don't know. And defendant's not repaid. It's just a form complaint with no proof, right? So what proof they have, we're going to take a look at. You'll notice on the bottom there, please understand this is a communication from a debt collector. This is an attempt to collect a debt, and any information obtained will be used for that purpose. That's sugar on a bad thing. So they're saying, do you mind if we collect as debt collectors? And by the way, anything you say will be used against you. Please understand, that's not part of the mini Miranda. And if we can just go back to that first page of the lawsuit, Shazam, I just want to point something out to you. Look at that first sentence, that first paragraph. Remember, every paragraph is numbered. You've got to answer every paragraph. So this says, plaintiff's authorized to file the complaint in this court. Plaintiff owns portfolios of consumer receivables it attempts to collect. Plaintiff strives to treat its consumers, such as defendant, with respect, compassion, integrity. Bullshit on that. That's just if the judge is reading it, oh, these people are nice. Hoping to provide mutually beneficial opportunities for consumers to repay their debts and attain financial recovery. Nobody is trying to do that for you, and don't get suckered into that BS. So the first paragraph, like I said, is just self-serving nonsense designed. It's adding sugar to make the default go down. Just think about that. So in reply, we put up our response. Now remember, we found the linchpin. We want to go after the linchpin. Now, if you find a way on the internet to answer a lawsuit, it's going to go admit, denied, not sure. Don't do that. You have to put nuances and detail into your answer and ways that the judge can hang their hat on your belief that you don't owe that debt. So where does the judge get educated from? Admit, deny, admit. You're just another number and you probably owe the debt. Now, if you come in the Parker way, now you've got his interest. I tell you, I get calls and emails from judges, clerks that go, oh, thank God. We have to default these people and nobody does this, but Parker, you're right on this. I'm not patting myself on the back. I'm just saying, even judges, clerks, who by the way, most of the time make all the decision, they just pass it on to the judge. They know nuances. They know good answers. These are good answers, hopefully for you. So if we put up the first page and that says Midland Credit Management, then you put your name in where it says defendant. You've titled it Defendant Answer, Affirmative Defenses. You're announcing what's going to be following. And then the Parker way. You put a preliminary statement and you say preliminary statement is to no stated claim. Let's go to the second page. And we just detail what I see, what you see. So when you break down with those first 5 things I told you at the beginning of the video, you put those things into your counter affidavit and they go into your preliminary statement. Remember that counter affidavit, it swims through the litigation seas. It has so many places and supplement possibilities for you. Here in your preliminary statement, you're showing the court, what's a debt, what's an account? And then you say at number 3, this is all BS because look at the linchpin. They're saying MPLI Capital Holdings owns this debt and established an account. No trust ever established an account. In this case, it's Cross River that then securitizes and sells it to a trust. By the way, that's not even one of the trusts that are part of this loan. I found a whole bunch of others just with this loan, but they throw in MPLI Capital Holdings, the 4th, as having created an account. Don't believe me? Look at this next part, loan agreement and promissory note, Shazam. And there you can see it says Cross River Bank is the lender, not MPLI, somebody's trust company. So they'll write these complaints that are totally contradicted by their own paperwork they say supports. It used to be I'd go, wait a minute, maybe they mean this, no. It's just 3 or 4 departments in different states from the same company putting all this stuff together 1,000 million times a day and no one cares. Well, you do, and this is how you go after them. So you found your linchpin, which is any reference to MPLI owning, or they're claiming they're the original creditor. We also see, let's look up the date that this lawsuit was filed, Shazam, is 6/4, yet their affidavit to the court where they say, let's put up the affidavit, Shazam, and that's their affidavit telling the court, MPLI got this whole thing going. It's their own loan agreement contradicts their own affidavit that they have signed, let's say April 25th. It looks like 2024 to me, but I digress. And they have signed that 25-24. That's a month and a half before the lawsuit was filed in June. That makes a difference because a lot of affidavit, account stated statutes require it be done in Michigan, you've got to file and sign the supporting affidavit less than 10 days before you file the lawsuit. It's impossible on a debt buyer level. Let's look at the bill of sale, Shazam, and that's just telling you Upgrade has sold the debt to Midland Credit Management with no reference to MPLI and no reference to the original creditor. So this is stuff you learn when you break down their lawsuit. Again, there is an enormous insecurity by debt buyers. They know they've got crap, so they add affidavits and this and that, and that's all insecurity based, and it just makes things worse for them. But 90% of these cases default. That's a fact under the latest view and analysis of the CPFB, and they have found that 90% of these cases are defaulting. So they don't care, but you do. So you're the great 10% that's going to do great. Remember we talked about governing law? Let's look at the governing law provision in this case. It's right on that same page. It's supposed to be brought in New Jersey. You make hay with that. You use that. And you say, and let's put this up, Shazam, as plaintiff has no standing to sue by its own documents and plaintiff's false affidavits, as shown by defendant's counter affidavit, Exhibit 1. You make sure counter affidavit is Exhibit 1. Exhibit 2 is their complaint and schlock, saying see schlock at Exhibit 2. Then you have your answer and affirmative defenses. I've laid it down for you. I've answered each one. The main thing that is the linchpin is your answer to the pleadings at 3. Let's just highlight 3 there for you. And that is your linchpin where you're going to win the case. You're pointing to Exhibit 2 and Exhibit 1 that MPLI is nowhere to be found in any of the plaintiff assignment documents. They aren't. They weren't assigned anything and they didn't assign anything. And there's nothing coming from Cross River Bank. Let's just look at 5 through 9, Shazam. Again, you have to answer every paragraph, and that's what we're doing. We're answering every paragraph. You can see in 7, and that's where we're citing some cases. Why do we do that? Interestingly, I'll be very honest with you, the case where it says Midland versus Mike Bassett, that's a buddy of mine. I took that case, and he took it to the Court of Appeals, and he beat Midland Funding twice. He's a good guy, and we stay in touch. So I know these cases intimately. In your jurisdiction, know the case that shows an assignment must be blah, 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 and you put it in your paragraph where you say denied, and you show why. You're supporting eloquently and intelligently for the court. Here's why. You start quoting these cases, and the other dummy on the side is like, I got 160,000 of these cases. Which case is this? You take advantage of their bad, you be their nightmare. Take advantage of their bad, unartful way of writing these things. Remember, there's a volume business over there. They don't care what it looks like. But the volume of one is you. So you do care, and educate the judge how great you are, how smart you are, and both the judge and the other attorney need to get this out of their lives. And that's a true thing. So let's look at the affirmative defenses, Shazam. You can see before that, I write a wherefore. That means this is what I want, court. Defendant seeks a no cause against plaintiff and statutory and actuary damages. You're always asking for everything you can in the kitchen sink, and then you come to a meeting of the minds or the middle point or a compromise of, in this case, we got a nice mutual walkaway of a lot of money. But your affirmative defenses point out what your counter affidavit points out, what your analysis of the bad assignments point out. In this case, I put number 8. There's no proof supporting the lawsuit and this is the Michigan statute, under 600.215, that this affidavit is worth anything because it was filed more than a month before the lawsuit was filed. And then I do what I do. I incorporate, go to the next page, right before 9, I incorporate their bad documents into my affirmative defenses. The court loves this. This is a person that's taking the care to not say it, but to prove it. And that's usually, even if they've got supporting document that kills them, in this case Midland funding, and it's crap, their pleadings are just bad. Like I showed you that self-serving episode, paragraph number 1, and it's all vague and nonsense and unproven. You've got on number 9 there that shows you we're talking about the governing law. This should be in New Jersey. You're just providing lots of tripwires for both the court that doesn't want this nonsense and have to litigate, and this guy going, I don't want to lose to an unrepresented person. That's a big concern to debt collectors, by the way. And you're saying at number 12, the chain of title on the specific debt is unperfected, because it is. Plaintiff does not possess the required assignment. The thing about affirmative defenses, they are a form of pleadings. And if you don't bring it, you lose it. So don't overdo it. There's an expression, oh, it's boilerplate. Boilerplate means you just painted everything. You got 25 affirmative defenses where only 5 apply. That's boilerplate. You want to be specific because that's, again, that's an educated, detailed, put some thought into this person that the judge will respect, and they begrudgingly will respect as they ask you, just want to get out of this. Believe me, all day long, I know this from personal experience and from hearing clients, especially in Zoom, I hear this. We went into a waiting room and we discussed the case, and they often tell me when my members or people like yourself on the channel, I presented this stuff to them and you could see that the guy was shaking and didn't understand. And it makes a difference. If he's worried about you showing him up, he or she, they'll get rid of this case. They pay pennies on the dollar. They can get rid of it, trust me. So you're going to go to the last page here starting at 14, Shazam. Another entity or creditor or secured trust or ABS owns the rights to this debt. You put it right in there because that's the truth. So you want to finish this off with your wherefore clause. It's called a wherefore clause of what you want. Here's what I want. And you want out. And you can see how I detail it. Check your state rules and your facts. You always need, I ended this video the same way as I'm gonna end it now as I did yesterday. Proof of service. You always have to have a proof of service that whatever you did in the court case was done. Often, if you must send it to the court and you must send it to the other side, and your proof of service must say that. And you'll see, you didn't send me that. Your Honor, you didn't send me that. I've had where the judge opens and goes, I've got the proof of service that he did. It makes a difference. It can save you, okay? Always have your proof of service. That's a question I get. Do I always need to use a proof of service? Yes is the answer. Make sure you have a proof of service because it will protect you. So that's the end of this debt buyer video. You can apply, what I'm doing is I'm trying to go as deep as possible to show you paragraph by paragraph what to answer with, and showing you, because people call me and go, I saw that video, but what do you mean by that? I go, okay, I did a crappy job. Let me go more detailed. So this, while it is a Midland Credit Management video, it is a debt buyer video that you can apply to any debt buyer case, including student loan private debt. They're all the same schlock. This is good. This makes you educated, and I want you to win. And you put up a good first impression, you will settle this, or they'll eat it, or you'll be very happy with the result because they don't like an educated person, which you will become after viewing this video. Thank you very much. Let me know, like, love, and subscribe. Let me know if there's videos you need. You'll notice on my YouTube channel and on my membership channel, if you write me a note, I'm going to try to answer it. If I do get a little bit of sleep, but this is a 24-hour job. So if you have concerns or comments, let me know. I will respond. Thank you kindly.